I'm personal injury attorney Jeff Edelman. Today we're going to talk about discovery. Discovery is the investigation portion of your lawsuit. It is the fact-finding area where both sides learn what facts will and will not be heard by a jury. Now, there are things that can be discovered in the discovery process that are not heard by a jury that may lead to some evidence that will be heard by a jury. But just because something is discoverable does not mean it is admissible. I'm going to talk about the written discovery to start. This includes interrogatories, requests for production, and requests for admissions. Now, interrogatories are questions. They're questions that you receive from the other attorney representing the opposite party on your case, and they're to be answered under oath. You have to sign them in the presence of a notary. The common questions that are asked in interrogatories are your full name, if you've been known by any other names in your life, your birthday, your work history, where you've lived the past 10 years, any injuries that you've had in the past 10 years, any doctors you've seen in the past 10 years or even in your entire life. This is the basis for the deposition that you will have to give as a plaintiff in a personal injury case at a later time. I'm going to talk next about requests for production. This is where the other side asks you for documents in your possession that are necessary for the proof of the claim or the defense of the claim. It could include photographs of the incident, medical records from the incident, or medical records in the past. They may ask you to sign a medical authorization as part of the investigation of the claim. So written discovery, request for production is exactly what it sounds like, producing documents that are relevant potentially to the case. I also want to bring something up with requests for production. Lately, social media, Facebook, Twitter, those things are discoverable. What you put out there for public consumption is discoverable. So if you do have a personal injury claim, just know that anything that you post, you may be questioned about at a deposition. So just keep that in mind and be careful. Request for admissions is the third written discovery topic I'm going to talk about right now. This is the scariest for me because basically these are statements where if you don't answer them in 30 days, everything is deemed admitted. You have to admit or deny the truth of the statements that are presented to you. So it's one of the things that I answer almost immediately when they come into my office. I don't let it get to day 25 because, again, if you don't respond within 30 days, everything is deemed admitted by law, and the statements can be read to a jury at trial. Now, if by chance your attorney misses the deadline, you can get an extension on it. You can have the admissions admitted late, but it's not something that any attorney would ever want to do. You want to get it right the first time. If you have any other questions concerning written discovery, my name is Jeff Edelman, and I can be reached at 954-341-2777.